I will now call the case on the 10:30 docket, 123647, State of Kansas versus Anthony Darryl Allen. Counsel, please come forward.
Good morning, Your Honor. May it please the court. I'm Jacob Gonteski. I represent the plaintiff, the appellee, the petitioner in this case, the state of Kansas, present and ready for argument.
Morning, Chief Justice, Justices. My name is Adam Sokoloff, and I represent Appellant Anthony Darryl Allen. We are present and ready for argument.
Thank you, Mr. Gonteski. May approach.
May it please the court. I'm Jacob Gonteski. I represent the plaintiff, the appellee, the petitioner in this case, the state of Kansas. And I'm requesting 3 minutes for rebuttal, please.
3 minutes will be granted.
Thank you. We're here today to talk about Anthony Allen and his right to a jury trial and his right to counsel in that jury trial. Anthony Allen was a challenging client for the 5 appointed attorneys who attempted to represent him over the course of his case. And Allen vociferously pleaded with the district court to permit him to represent himself throughout the proceedings. After his conviction, though, Allen claimed that the trial court erred in granting exactly what Allen had requested every step of the way, and that was his right to self-representation. The Court of Appeals, acting on an incomplete record after Allen failed to designate transcripts of several hearings before the trial, concluded that while the trial court did sufficiently have a colloquy with Allen before the eventual trial to ensure that he wished to represent himself, his right to represent himself at trial was ultimately protected. But the Court of Appeals found error in that the record lacked a sufficient waiver of counsel for a pretrial period of 14 months. And specifically, the Court of Appeals addressed 2 hearings within those 14 months that the Court of Appeals found to be critical stages of the proceeding in which the record failed to demonstrate that Allen had executed a sufficient waiver of counsel before those hearings progressed.
That was res sua sponte, correct? About the hearings.
I would argue it was. The opening brief in this case that Allen filed argued that his right to counsel was violated, but it did not specify those 2 hearings. And I noted as much in my opening brief with the Court of Appeals. And then the Court of Appeals really zeroed in on those 2 hearings, the March and May of 2018 hearings.
What evidence did they use then at the time to justify what they found about the existence and what happened at the hearings?
The best I can discern from what they used was the bare ROA, the record of actions produced by the district court, which is a very cryptic document that outlines in 1 or 2 sentences at most.
Is that appropriate evidence?
I argued it was not. And I argued that in the petition for review here and in my supplemental brief, that was an insufficient basis upon which to find the trial court erred, particularly given that in the absence of a record this court has held, it should presume that the trial court acted correctly rather than incorrectly. Now, a portion of that record, at least, has been remedied to an extent. And after filing the supplemental brief in this case, after the state's petition for review was granted, I filed the supplemental brief. And after that, the parties reached a settlement of the record pertaining to the March and May of 2018 hearings. And if the court will recall, those were the hearings in which transcripts had not been produced. The court reporter was no longer available, but what the court did have was some some cryptic notes are the best way I can describe them from the hearing that had been produced by the court reporter at the time, but they never got decoded by the court reporter. And so the parties requested that we requested jointly to add those to the record on appeal. This court requested that rather than add those unofficial transcripts, that we conduct a settlement proceeding at the district court, and we did so.
Can I ask, just backing up
Yes.
in the procedural steps, the state has the ability to supplement the record, right? I mean, was there a designation of those records before briefs were filed at the Court of Appeals?
No, I did not request those because part of my argument in the Court of Appeals was that the appellant had failed to designate a sufficient record to establish his claim of error. The burden I was arguing was on him to establish the error, and in failing to designate a sufficient record, I did not seek those transcripts to that end. Now that we have the settlement of the record, the parties did not engage in further briefing. The state, at least on the state's part, I believe my supplemental brief that I had filed before we reached the settlement of the proceedings ended my ability to brief further these issues. But I would note, I believe the settlement of the record clearly demonstrates that in particular for the second of the two hearings, the May 2018 hearing, in which the 6455 motion was heard and the defendant's motion to dismiss was taken up. In that hearing, our settlement of the record demonstrates, I would argue without a doubt, that a full colloquy was conducted with Mr. Allen in which he definitively waived his right to counsel. The court went through exhaustively all the low factors and the dangers of self-representation and why the court always advises defendants against that course. Even the state went on the record noting that it was not a course of action that Allen should take. So in the May of 2018 hearing, I believe a full and sufficient waiver was conducted. The hearing 2 months before that, the competency hearing, the third.
Let me just interrupt you very
Yes.
quickly. I'm looking at my notes and the only thing that, what exactly are you relying on in the May 2018 from the settlement of the transcript? Is that what we call it? Settlement of the record. What are you relying on at that May 2018 hearing that tell us that it was definitively waived?
When within our settlement of the record in the May of 2018 hearing, if the court has the settlement of the record in front of it, page 3 through page 6 are the portions pertaining to the May of 2018 hearing. And in that hearing, the court went through asking Allen about his educational background. The court noted that it had been through many of this before, but wanted to walk through it again. Asked if he had any legal training, asked what Allen had reviewed in preparation for representing himself, and noted that Allen's attorney had indicated there may be motions that Allen would want to file, asked Allen if he had done research on those motions. The court asked Allen if he understood that if he proceeded to trial by himself and asked inappropriate questions or failed to follow procedure in selection of the jury or in opening statements or in closing arguments or in cross-examination, he would not be able to proceed and the court would have him sit down. The court asked if he understood that he was going to have Mr. Thomas as standby or backup counsel to ask him any questions he could at that point, and that at any point, if he represented himself, he could have Mr. Thomas take over.
How did those items compare with like the low factors?
When we go back to the low factors, while setting forth 7 or 8 specific factors, the gist of low talks about making sure that a defendant fully appreciates and understands that they have that right, but that with that right comes certain burdens or certain risks. And those risks are that you may not fully understand the law. You may not fully understand objections and how to respond to objections. You may not understand how to admit evidence or what the protocols of the court may be. And the fact that you don't understand those can be to your detriment. And when they're to your detriment, the court won't come to your rescue and the state won't come to your rescue. And so several of those low factors are basically an effort to impress upon a defendant seeking to represent themselves that doing so puts them at a deficit. And so Judge McCarthy went through many of the ways in which self-representation would be to Mr. Allen's detriment.
Okay, and then as far as the burden steps on this, whether he appreciated the consequences of his decision, is there anything in that colloquy that besides saying, I'm not going to help you and neither is standby? Or the third burden step, you understand the punishment that could happen. You understand the charges and the proceedings and the punishment and, you know, the overall facts of this case and what can happen to you. Was there anything in there about that? And I know that, you know, these aren't mandatory, right? There's no list required.
Right.
Nothing.
Right.
So when I ask these questions, they're just what you know, factors you can consider for
Correct.
knowing and voluntary waiver.
Understood. While those explicit ones were not stepped through in the same language that Lowe used, although that did occur in other hearings when the state provided the district court with a copy of Lowe and requested it specifically go through the Lowe factors. But in this hearing, it did not go through the Lowe factors explicitly. But in
Or the
terms of
burden factors,
I'm sorry,
or burden.
or burden factors. And when you say burden factors, you're referring to the risks that the defendant faces in representing himself.
And appreciating the consequences of the decision, yeah.
I believe those would be rolled into the court's impressing upon him that if he did not follow the rules of the court, the rules of evidence, that he would have to sit down, he wouldn't be able to continue to represent himself. And the court asked Allen again if he still wished to proceed in representing himself, and he said yes. He then later said he wanted to fire Zach Thomas as counsel altogether. Even the state went on the record in paragraphs 22, 23, noting that it had concerns that Allen would be required to operate within the rules that the state is also bound by. And the state wanted to ensure he received the fairest possible trial, but he wanted to understood that he knew the risks he was facing. And that colloquy on the issue remained important to keep checking with Allen that he was fully aware and understood those. And he continued to indicate that, yes, he wanted to represent himself.
And what
every
about
step of
that?
the way.
And the March hearing?
The March hearing was much shorter. The March hearing was the third of 3 competency hearings. And in the March hearing, I would agree, that even our settlement proceedings do not demonstrate a complete waiver of the right to counsel within the limited transcript portions that we have.
What are the ramifications then of that proceeding happening without counsel in terms of critical stage and structural versus prejudice versus harmlessness?
I appreciate the question because that's where I want to get to
Yeah,
today.
sorry.
No, do not apologize. That I believe is the crux of what the court has in front of it today. That the state acknowledges was a critical stage. A competency hearing is a critical stage of the proceeding under Ford and other cases. But he was never prejudiced because he was found competent in that hearing as he had been at the previous hearings. And he never contested that he was competent. He never raised competency at the Court of Appeals. He never argued at any phase of this case, he has never argued that the trial court erred in finding him competent. And because it was and I'm recognizing my time is exhausted, may I continue to respond? Thank you.
Yes.
This issue of the deprivation of the right to counsel at a pretrial proceeding that is ultimately corrected before the eventual trial or plea lends itself to the harmless error analysis and should not be deemed structural by this court. It lends itself perfectly to the harmless error analysis because we can step through how could that proceeding have been better for Mr. Allen. Likewise, with the May of 2018 hearing, we can ask what prejudice befell Allen by virtue of him not being represented at that hearing. When we look to the March hearing, it was that he was found competent. When we look to the May of 2018 hearing, his motion to dismiss the case was denied. It was a 1-page motion that entirely lacked merit. The court can see that motion in the record on appeal. The district court and the Court of Appeals acknowledged without issue that that motion lacked merit on its face. So his motion was denied. In that May hearing, the state sought to admit 6455 evidence against the defendant, and the state's request was denied. So when we look at those 2 hearings.
Actually, part of it was deferred. wasn't it?
It was
It was either denied or deferred.
until trial, correct.
But why would we look to the merits of a pro se motion as the measurement for harmlessness? I mean, isn't that the very reason you'd want counsel? Or is it too speculative to say what counsel could have done in that instance in terms of dismissal?
The motion was a pro se motion that Mr. Allen wrote himself and filed with the court. And before the trial was conducted, a full and complete waiver was done. So either when counsel stepped in or after the waiver was complete, there was still a continued ability to file any motions that any party would request. And the reason why this should not be deemed structural error and automatically reversible in every instance is because in a pretrial proceeding such as these, we can examine harmlessness and it does not infect the trial itself. The trial itself is where we examine the right to counsel. And that the crux of all of this, what all of this is leading to is the trial.
Okay,
And
I'm gonna push back a little bit on that. On the competency hearing, the state was the one who suggested to the court that there should be a competency hearing. And the court agreed to order the competency hearing. So at some point that lends itself to an implication that at least the state and the court were concerned enough that they got the competency hearing. So then we know that he was not represented by counsel at the competency hearing. So the difference between whether or not we can make a determination as to harmlessness, as I understand the Supreme Court cases, is that we have to be able to determine that we cabin the error to only that one hearing and that it does not affect or taint or infect subsequent hearings or the structure of the trial itself, of the proceedings themselves. So this is my question on that. Some circuits say, well, you can have a harmlessness analysis, including the 10th Circuit. We can just send this back and say, okay, a couple of questions, go through this 4-factor determination to determine whether or not we can have a retroactive competency hearing to begin with. And then if so, have that competency hearing with benefit of counsel and determine whether or not this person is competent. In this case, that did not happen. So then with regard to the request or the waiver of counsel, there's an additional test for competency, which is before you can even ask the defendant whether he wants to waive counsel, there's a presumption that he is competent to make those determinations that I would argue are a higher level than simply being competent to stand trial. So what is your best argument that what was done at the competency hearing that was to find that lower level of competency without benefit of counsel to ask questions, present witnesses, or to do any of those things? What's your best argument that that didn't affect that next hearing, which also addressed the higher level of competency to waive counsel?
I don't believe any error in the March competency hearing would have infected anything that occurred in May, because we know from the record as it marched forward that a complete waiver was done repeatedly in the months that followed before the trial at multiple hearings. And we know that Zach Thomas, who was, I'd argue, more than standby counsel, Zach Thomas was at Mr. Allen's side through the entirety of the case at every hearing. He frequently entered his appearance. He spoke about visiting Mr. Allen in jail, discussing motions with him, providing him with legal research. And after the court found him competent at the March 2018 hearing, no one raised a flag about competency in any way. Not defense counsel, Mr. Thomas, not the state, not the court. And repeated waivers that occurred before the trial evinced his competency to waive that right. By virtue of the record that we have that shows him responding to the court's inquiries and appreciating the consequences of his decision, understanding the nature of the case, understanding the risks, understanding the potential sentence that he faced, and so on. And even when we got to trial and he began by representing himself, he then requested partway through the trial that Mr. Thomas come in and represent him full on and conduct some examinations of witnesses. And so there's nothing in the record that would indicate the court's determination on competency from March of 2018 was in any way incorrect. Likewise, post-conviction, when the case went up to the Court of Appeals on appeal, Allen never claimed, with the help of counsel, with the help of appellate counsel, Allen never claimed that the court erred in that competency hearing or that he was incompetent or procedurally somehow failed in protecting his rights below.
Why would he if he's incompetent?
Because he was represented further on and there were individuals there to raise that issue if it in fact was a meritorious claim, and no one ever did.
Here's my issue, okay, in putting it in its simplest terms, explain to me. If in March, he is determined, as you say, he's determined competent without, with right to counsel being deprived, and competency, as you say, is never raised again. And so then he gives up his right, you could say, for purposes of your argument, we'll say in May of 2018, although I'm not sure, but definitely later, in July of 2018. So when he gives up that right in July of 11th of 2018, we don't know whether, we still have this erroneous issue of whether, we have the error that permeates, now it's permeating everything. Because when he gives that up in July of 11 of 2018, he could be incompetent. We don't know because we deprived him of his right to counsel. And then he goes into trial representing himself, permeate. It does seem like it's structural error and that can't be analyzed because structural error is that there, it affects and permeates the entire trial process.
We need not assume that what occurred in the March of 2018 hearing was erroneous and permeated anything when we have 3 competency evaluations that were conducted where doctors repeatedly found Allen competent. And then the court itself repeatedly went through colloquies that were more extensive even than Lowe in discussing all of the competency question.
Then why did the judge order another competency hearing?
Because I believe the state requested as
Exactly.
the state requested as much based on observations of him in the courtroom and so on.
Right.
We have.
But the competency question itself, if you look at the competency evaluations, what they examine are things like appreciating the roles of the parties, the risks he's facing at going to trial, what a potential exposure is, what the role of the court is, what the role of defense counsel is, what his role is, how witnesses will be presented, right from wrong. All of these sorts of questions that get asked in a competency evaluation are all rolled into the colloquies, the repeated colloquies that Judge McCarthy had with this defendant in the run-up to trial.
Right,
And so
but
even
that's
if
not taking into account what happened in March, that he was deprived of his constitutional right to counsel at a what are we calling it? A critical point of trial, stage of trial.
Well, that would seem to discourage the state from ever requesting a competency evaluation. To
No,
assume that it would be structural error if he was deprived of his right to counsel in that scenario. But in any event, what we have is, I would argue, even better than a competency evaluation from a doctor that went and visited him in jail, which is we have these extensive colloquies that took place between the defendant and the court in the lead up to trial to know whether or not, if an error had occurred in March and he was somehow, if we're going to assume he was incompetent at that point, which it seems as though the court wants to do, even if you assume as much, you can look at the record that took place after that and in the run up to trial.
then why would we ever request a competency hearing if a judge can determine competency without the finding on the record?
But
Based on,
But the judge still had the competency evaluations from the doctors
but
who
the
are,
defendant was not represented.
he represented himself.
We agree, though, that at a competency hearing, someone must have counsel.
It's a critical stage of the proceeding in which you have a right to counsel,
Well, it's a competency hearing.
right?
State has already, there's already a question of whether he's competent. So it would seem that we can agree that he must have counsel at a competency hearing, right?
I would agree.
Okay, once competency is found, for all subsequent hearings and subsequent stages, competency is presumed, correct? We have
Correct.
case law to say that.
And it's presumed from the outset of any criminal case.
Right, so but after the competency hearing, it's presumed, because that changed. When there was a request for competency hearing, it was no longer presumed, it had to be proved, right?
If that's the position this court would take, that will disincentivize individuals from requesting a competency evaluation.
Why?
Okay, well, what if it does? If at the competency hearing, if there is a finding by the district court that the defendant is competent, then that finding of competency remains until he is proved to be incompetent, correct?
Until another,
Right.
until another competency evaluation or so on.
So all the subsequent hearings and all of the colloquies that had to do with his Sixth Amendment right to counsel began with a presumption that he was competent, correct?
Correct.
And just skipped over that part of it to go to the colloquy and to the waiver, correct?
Correct. But we have absolutely nothing in the record demonstrating him to be incompetent. We have an evaluation from a doctor that's part of the record that the court accepted in a hearing in which the defendant was present, in which the court found him to be competent and
And-
stamped.
And you believe that can be fixed if we go back and retroactively have a competency hearing with counsel?
That would be one way, but I believe it could be evaluated under a harmless error analysis, which is the gist of what the state's requesting here today, is that it not always be deemed structural.
Without
The-
doing it again?
The state can certainly do it again. If that is the approach that this court would request to ensure that it was done the right way, the state's absolutely open to that.
Here's my concern with your position is that basically what you're saying is that subsequent determinations, subsequent hearings, when Mr. Allen was deprived of his right to counsel, can be cured later by some procedure.
And other courts have found as much, and other circuits have found as much, and the United States Supreme Court has found as much.
Why does any right to counsel attach, or what's to prevent what's to prevent what happened here? Or even his appearance at a competency hearing, if it can be later cured. How do we address that?
It's addressed by the body of case law that says it's a critical stage of the proceeding. He has a right to be there and has a right to be represented. And there's still the harmless backstop. I'm not here arguing from the get-go that you should just find a defendant can be waived of counsel at any pretrial hearing as long as it's remedied before trial. That's not my
Why
argument.
aren't you arguing? It seems to me that's what you're arguing.
That's not what I'm only arguing, that in a pretrial proceeding where a right to counsel is deprived, it should not be deemed structural to have infected the ultimate trial as if it was remedied before the trial or the plea. The court should at least examine harmlessness. That's not to say the state would always prevail. That's to say that the impact of it and whether or not the defendant was prejudiced by it should be considered. If he came in for that competency hearing on Monday morning at 9 a.m. and counsel didn't appear because they were late and the court said, we're going to go for it anyway. I've read the report. State have any objection to it? I'm going to find him competent. I find him competent and off we go. And then at 2 p.m. that day, counsel shows up, says, I lost my calendar. I can't believe I missed that. And the court says, I found your client competent this morning. We're going to go on next week. We're going to have another hearing, XYZ. Under the structural error analysis, his trial would be infected by that. We'd be reversing a trial in which this woman testified about having been kidnapped and held for a month.
No, they
And we're
would
going to
have
bring her
another,
back years later.
no, the judge would say, okay, well, we'll have another hearing so you can raise objections to the report if you have them on behalf of your client.
But if
That was never happened here.
it didn't happen here, but he had counsel at his side in these hearings who could have said as much if he believed as
He was
much was
stamped by
necessary.
counsel. It wasn't his counsel. He was self-represented. And that's the whole point. What I'm talking about, the difference between structural and harmless is it infects the whole trial. And in the hypothetical that you're giving, it wouldn't, because it would have been remedied by saying, oh, I understand that that you had a time thing. Let's, you need to have an opportunity on behalf of your client to object to the report and tell me what you think.
And examining that remedy that happened later in the afternoon would go in a harmless error analysis. Because if that's the way it happened, it would still be that the morning hearing was a critical stage in which he was unrepresented. And under structural error analysis, it would unwind everything.
So
If
am I correct in understanding your argument to be that the difference between structural error and harmlessness in this particular fact scenario is in fact the merits of the competency hearing? In other words, if he was competent in March of 2018, then it's harmless.
Absolutely.
If he was not competent, it's arguably structural.
I
And
wouldn't
this is
argue
the-
it's structural. I would argue that the harmless error analysis would demonstrate he had been prejudiced and thus the conviction should be reversed.
But the
It-
key
but-
question is, was he competent in March of 2017? And this is what we don't know. And so the question's already been asked, but it strikes me you're just wondering why you're not arguing for a retroactive hearing.
And if that is, I'm arguing that it shouldn't be structural, because if it is, we don't even get a chance at a retroactive hearing. I'm arguing it should,
But my point is it's circular. The two things are intertwined. You can't decide whether it's structural unless you first know that he was incompetent.
understood. The state would be absolutely open to and welcome a retroactive competency hearing to evaluate the defendant's competency in March of 2018. If that is an avenue by which the state could demonstrate, in fact, he was competent, no error befell him, he was not prejudiced by the lack of counsel. And that's why I put it under the umbrella of a harmless error analysis. If we stick to a structural error analysis, I don't believe the state ever even gets to request.
I'm just suggesting that this court, at least arguably, cannot even decide which rubric to apply, which reversibility rubric to apply, unless you first have the factual question answered.
Then to that extent, if the court is struggling with that question, I would welcome the
I
case
might be
being.
the only one.
No, understood. But if this afternoon it's decided that that's the avenue, the state would welcome a remand to the district court to conduct a retroactive competency evaluation going back to the March of 2018 hearing. That's absolutely, and to answer the question as to why the state that wasn't an avenue the state was pursuing. Frankly, I just didn't see it in that I felt as though being cabined to structural error, I would never get a chance to request as much anyway. So that's why I've pushed back on.
The judge said, well, we've got a report. Anybody object?
And 99% of competency hearings look just like that.
Well, from what I've seen, 100% of the competency hearings have benefit of counsel. So that's why I want to focus on that.
Understood. And I think we can still examine whether or not it was harmless. I'm not seeking to deprive defendants of their right to counsel at a competency hearing. Everybody should have counsel at their side at a competency hearing. What I'm saying is we can still examine the available record to demonstrate, to examine whether or not Allen was prejudiced in any way. I just want to get to the prejudice question, and I can't get there if this court sticks to the structural error analysis.
Thank you, Mr. Gonteski.
Thank you.
Sokoloff?
Adam Sokoloff for appellant Anthony Darryl. Denial, right to counsel at any critical stage has long been, is right now as I stand before you, and should continue to be deemed structural error, not amenable to harmless error analysis. This court should continue that precedent, not only because of the long-standing jurisprudential commitments to the rights emanating from the Sixth Amendment codified in our state laws in 224503, not just because it's a bulwark for the fundamental rights, as our justices have talked about, things that have long been regarded as not subject to harmlessness error, but beyond that, the alternatives are unworkable, both for the bench and for the state ultimately. The alternatives proposed here by the state that we would engage in these speculative inquiries into the world of possibilities that may or may not have manifested themselves had things been done differently. That's the world of speculation into the unquantifiable and indeterminate that Jones tells us we shouldn't do.
Why not,
Furthermore,
why
the
not
record
a,
supports harm.
sorry, didn't mean to cut you off there. What's the problem with a retroactive competency hearing? I mean, what's unworkable about that? And if it is, isn't there an opportunity to make that argument
I would say
as to
two-
workability?
I would say two things. One, retroactive competency evaluations are not probably the solutions that this court's looking to create out there. If in fact we even could sign into the various rubrics that we'd need to make that finding here. Two, I don't know if they're legitimately possible for the actual providers of those competency evaluations to say into 2024, evaluate if it's a different provider, what his state was in 2018. And then even more so, we're also forced to take a sort of specific examination of what may or may not have been the appropriate argumentation available to counsel at the time. And some of that is impossible for us to look at now because we don't know one of the most important things here that makes the relationship between a defendant and counsel so critical is the conversations they have. We will never know what defense counsel gets to know because they get to talk to that person. They get to meet with them. They get to see them interact. They get to, as some of our justices are asking questions about, observe their demeanor, which provoked not once, not twice, but thrice competency evaluations in this person's case. I mean, after two medical professionals deemed him competent, was adopted by the court, a third evaluation was requested. So
Let's say
retro-
that the facts are exactly the same. March of 2018, the request for a hearing is made. And for whatever reason, it just falls through the cracks. The hearing never happens. And now we're, 5 years later, 6 years later, looking back, oops, should have happened, didn't happen. Is that structural error?
Yes, it is, Your Honor. It's a critical stage where they weren't represented and there's no ability for us to calculate if it affected.
Well, but we wouldn't be talking about representation. We would just be talking about the fact that the hearing didn't happen.
Oh, I'm sorry, I misunderstood your question. Just if the hearing never got
Yeah, it just
scheduled,
doesn't
it would be
happen.
heard. I think it would be, it's difficult to say not knowing if the person was represented and the hearing never happened in the hypothetical.
Let's say the person was represented throughout. The hearing didn't happen.
I think it still is not amenable to harmless error because again, we have specific requirements for what it takes for a court to find that they're competent to proceed to any of the other stages, as it goes along. Absent that record, we don't presume their competency if it's been called into question and never sorted out. I guess that's where we would land, is that we presume competency absent.
Wouldn't that mean that you would never have a retroactive competency hearing? Which we know we do. Because if you, if there's a problem and you didn't have one, then it's structural. That's your argument. So why would you ever have a retroactive here?
Well, in our case, I think we have to cleave apart the difference of if you didn't have one and you were subject to some other fundamental right being deprived, like not having.
Well, that's the heart of my question is what is the difference? I don't see a difference, or at least I'm asking you to point the difference out to me between simply not having the hearing versus having it in an unrepresented fashion.
And I think that forces us into this untenable world of speculation, which is functionally, I might agree with some of the characterizations of how competency hearings do often go, and that it might not have been any materially different, represented or not represented, having the hearing or not. having
That's
it.
not my question. My question is, what's the difference between a competency hearing that never happens and one that happens in an unrepresented capacity?
Because the hearing that happens in an unrepresented capacity is a known quantity of a missed opportunity for.
Yeah, it's exactly the
fundamental right.
same as if it had never happened, right?
Largely, yes. I didn't understand exactly where you're coming from, but yes, functionally, for a court, certainly in a reviewing court's position, there would be no meaningful distinguishment there.
Well,
And-
but isn't in Justice Stiegel's example, where it fell through the cracks and it didn't happen, but the person was represented by counsel afterwards for all stages, critical stages, non-critical stages, was represented by counsel. The competency to waive counsel never comes up, right? Because he doesn't waive counsel. He's fine with his counsel. He's represented. But here, if we find he had no counsel at the competency hearing, was supposed to have a competency hearing, we send this back for a retroactive competency hearing to determine whether he was competent to stand trial. Still don't know what would have been done when for the rest of the trial, the judge was presuming he was competent to make all other decisions, such as waiver of counsel, correct?
And I think the sort of merits approach, as Justice Stiegel kind of labeled the state's approach, that this merit-based approach functionally makes the critical stage calculation a nullity. It makes it outcome-based. It means we go and we look later to see if anything actually happened. Was there this negative consequence? And I would like to point to this court's language from Jones and the longstanding United States Supreme Court definitions of what a critical stage is. It's when there's a potentiality for there to be significant consequences to the accused.
Do we even have to get to Jones if we find that it was structural error, that he did not have counsel at the competency hearing?
No, Your Honor, I don't believe you do. It is not subject under our current standing law. It's an automatic reversal. It comes back. I'm simply pointing out that the language that we have that supports the idea of what critical stages are do not require a negative outcome. It's not that there are significant negative consequences. So if they win, and so when Justice Malone had pointed out in their concurrence, which I'm sure puts wind in the sails of the state as they're here saying, we can look to harmlessness. In this case, we can't do that. There isn't the ability for us to do that. Jones tells us it's going to make us end up speculating wildly, and we shouldn't end up doing that. We know that this was error. We understand that it was error. And in fact, no one contends that it wasn't error at the March hearing. And I don't want to let go of the May hearing either, when the motions were there. As was mentioned in the concurrence from the Court of Appeals, the denial of the 64-5 seems to indicate there wasn't prejudice. And again, we keep hearing prejudice from the state's advocacy here today. The calculation of prejudice is not the calculation of whether or not there was a structural error. The harmlessness, remember, it's the state's burden, not only as the Court of Appeals noted in its opinion in this matter, that it's the state's burden to show there was a good waiver, that it was done knowingly. But I would contend that, as you pointed out earlier, Justice Wilson, the idea that the 64-5-5 motion was not denied wholesale. It wasn't thrown out as if it was, meritless. It was denied in part and deferred in part. We don't know what a competent real attorney in that moment might have had as a responsive measure to the representations of the state in that hearing. We don't know if there might have been prophylactic motions on the part of a competent defense attorney in response to the state's representations about what they intended to do with the prior conduct evidence. And in fact, in that hearing, the judge even says to the defendant, some of that evidence is going to come in though.
Why is that the test? I'm understanding the argument, and correct me if I'm wrong. Our concern at these hearings that the appropriate warnings weren't given. Went back and just looked. Isn't the question whether if the appropriate warnings had been given, the defendant would have made a different decision? And once you get to that, then you can maybe play a little more about what a lawyer may have done or not done. But if the defendant was headstrong, then it wouldn't matter what the warnings were.
I understand and think that's very reasonable. However, two things there. One, we're forced to speculate based on our assumptions of the record of this man that he was so headstrong, as Your Honor puts it, that he would have made the same decision. That is speculative. It is by definition. And two, we're allowing the state to kind of turn this into an IAC calculation for a pro se litigant. Basically, now the litigant, the defendant in this case, Mr. Allen, has to prove prejudice for you all to decide that there was error. That's sort of the terminal calculation that we get to from the state's point. We don't have to answer your initial question is why does that have to be the test? I'm saying we shouldn't have to sit here and argue to you all that we were prejudiced. Mr. Allen doesn't have to prove that he was prejudiced. And that's longstanding tradition. The error happened. That waiver was not good. No one is going to stand here and argue that waiver was good from March. So the question becomes, was it a critical stage, which Allen contends is really more of a categorical sort of calculation after initial threshold is met. If you all determined that this kind of a hearing, this class of hearing, whatever it may be, has the potential to have significant consequences to a defendant, it's a critical stage. That's how we've defined it. Don't have counsel at a critical stage, it's not subject to harmlessness. If you all bought what the state is selling here and said, okay, but we can in the limited scenarios where a pre-trial denial happened, but it was later corrected in advance of trial, for those periods, can we look at it harmlessly? And to your questions earlier, Justice Standridge, I don't believe we can. Similar to Fulminante with a different outcome is this idea that there were all these precipitous events that happened. And it isn't just these two hearings. At the hearing in the transcript you can read, Mr. Allen stipulated to a bunch of video evidence coming in. I don't know any counsel would do that. That evidence was a huge factor in the state's case. It was the corroboration for the lone victim. This was testimony. This was a conviction that was based on one victim's testimony. And then some people saying the things they saw, namely videotape and pictures, including the state's expert who all they did.
After July 11th, 2018 that he stipulated?
No, it was at the hearing there. In that transcript, the court has it. It's part of the complete record where they reference his stipulations. They also, in that transcript on July 11th, 2018 is the one you're talking about earlier, which I believe is the one where, that's the one we all agree a full colloquy was done. I disagree with the one in May. It did not meet low or burden.
So the hypothetical that we were talking about earlier, I don't know. You have a watch a calendar or something. So the judge gets court and says, I do. Next day, counsel, or that afternoon, counsel says, oh my God, I didn't calendar it. Can we have a redo? So there's a redo the next. That structural error? There's a redo.
I can understand the most extreme scenarios, hypotheticals might lend themselves to that. And I would say two things. One, we can't know. One errant comment from a defendant that's ill-advised that they wouldn't have made had they talked to an attorney can tank their entire case. One bad jail phone call, one stupid comment, one letter to the judge where they say something they shouldn't have. So in a period of hours, minutes, seconds, it could happen. And two, I'd say this is
That's harmless there. That's looking, if you're starting to talk about that.
well, I'm saying because
You know that?
because we can't know it, we say it's structural. It doesn't lend itself to knowing the myriad of possibilities that could have happened there. And secondly, I'd say that's a cost that should be borne by the state. Let's be honest, the error is attributable to the state. The error on the trial court's bad waiver is attributable to the state. The lack of a record is the state's fault.
Precedent about what structural error is, which infects the whole trial process.
And here I believe that we cannot ever, the state could never prove harmless or or the idea that it didn't infect the trial process, what happened during that 14-month period? Well,
No,
Mr.
I know, but I'm talking about my hypothetical.
That scenario where someone was just for a matter of hours, 24 hours. We are forced, and you all are forced with the difficult job to then say that we know beyond a reasonable doubt that nothing in that 24 hours happened that could have
Beyond a
affected
reasonable doubt.
the harmlessness error standard that the state would like to put forward if we were to consider structural errors under the harmlessness. And I guess to
Okay,
better.
so you are saying it could be analyzed, because I'm trying to figure out, whether we just draw this line that the minute it happens, it's structural error. When the Supreme Court tells us that structural error has to infect the entire trial process.
And I agree, and let me better answer that now that I understand, thank you. I would argue that there have been, as the state pointed out, places where what is considered to be presumptively structural error is potentially amenable to harmless error. Some of those cases, including the 8th, 9th, and 10th Circuit cases as cited, including Fitzpatrick, notably by the state. And I see my time is out. May I continue? I know we're not being sticklers for time today. I want to answer. Those cases all had one fundamental rule in all of them, which was that there were other things in the record that allowed a court to infer or determine that the defendant's waiver was knowingly and intelligently made. We do not have that here. The state is trying to have it both ways. They want you to say, well, you have to presume it was knowingly because he kept wanting it.
My question is, how does, in this hypothetical with the 24 hours, how does that become structural error? Well, it doesn't appear, why can't that be analyzed under constitutional harmlessness test beyond a reasonable doubt? Because it doesn't appear to,
Can, Your Honor, I'm sorry if I wasn't clear. It can,
Okay.
but provided, like all of the cases cited by the state, like Fitzpatrick et al., provided that the court can do the harmless error, provided the court can look at it in the context of things. And in all of those cases where this court and the Supreme Court has done that, the United States Supreme Court and the Kansas Supreme Court, in the cases where we've done that, there has been other things on the record. Here, this court can't point to anything else to suggest, certainly not at the time of March, certainly not in time, if not for 14 months, that there's anything that suggests he did knowingly and
I
intelligently
think
waive.
the point is, that would just mean when we take the look for harmless error, you win.
Correct.
And I'm still having trouble trying to figure out why we're afraid of a harmless error analysis.
In the end, I'm saying I believe that the current stance per Jones is the right rationale, and we, our advocacy is still, even if, and I've been clear, even if you adopted their harmless errors, they could never meet that burden. Any lack of record shows they don't have that. And furthermore, our record shows, beyond just the motions that we've talked about, is that this defendant engaged in mediation. That's in the record we have, in plea negotiations and communications with the state. He stipulated to meaningful evidence that was used to corroborate the star witness of the case. All of those things happened to show they could never prove harmlessness. However, still, just the nature that it puts a court in a wildly speculative inquiry into the, quote, unquantifiable and indeterminate consequences is why I still believe that our current jurisprudence is right, that it is structural. You do not pass go, you do not collect $200, we do not do harmless.
For my question, I just want to narrow it to March 2018, the competency hearing where he wasn't represented or where there was no valid waiver. If we all knew magically as a matter of absolute fact that Mr. Allen was competent in March of 2017, wouldn't that necessarily lead to the conclusion that that error was harmless?
No, Your Honor.
And why not? I knew that would be your answer, but that's what I want to hear
That would-
from you. How do you justify that answer?
Because that would only prove he was competent, which would put him in the same footing as every other defendant out there.
I know, but the universe of my question is narrowed to that hearing. Like, that's the outcome of the hearing is the reason you have an attorney. That's what I'm struggling with. Like, how do you?
I understand your question. You were right in that sense, but I'm saying we cannot divorce the March hearing for the next 14 months.
Okay, fair
Really
enough.
I mean, we have 14 months wherein, and I appreciate the state saying Mr. Thomas was there as standby counsel.
But you're
the
not,
record-
you're not saying that somehow there's a prejudice that extends beyond the substantive outcome of the hearing or the subsequent actions.
The unique finding of competence in that moment, I don't believe is something that it necessarily infected the trial. It is that
Okay.
for 14 months, he went without it. And let me tell you, on the record, multiple times, he says he wants to fire Mr. Thomas. That was referenced by the state. The Court of Appeals mentions multiple hearings in 2017, in August of 2018, on December 7th of 2018, wherein Mr. Thomas makes a record and says, he refuses my assistance. Quote, he refuses my assistance. This is multiple times. This was not, he wasn't functionally represented. This is, and we know from Van, from Sultan, from this court in Jones, we know that standby counsel does not suffice for counsel. For 14 months, he wandered around in the dark. This court says that waiver is about opening their eyes. The decision calculus is not on necessarily the words out of the judge's mouth, or even on us being able to prove prejudice. The error is about, did this defendant understand? Nothing in the record lets us indicate that he did. And so for 14 months, while meaningful motions happened, while an additional competency happened, while mediation, while plea negotiation, stipulations to evidence, all that happened in a 14-month period while this man was denied his right to counsel. The idea that we could say that didn't infect the trial, I think is not colorable. I don't believe that a court could get to, and if we adopted the harmlessness calculation as proposed by the state, this court would have to find beyond a reasonable doubt that that 14-month period did not affect the process of the trial. And I think it's important to realize that our courts have found that pretrial stuff applies. Jones tells us this right is as vested pretrial as it is at trial. Fulminante talks about this idea of communications with the state can be critical stages. Plea negotiations are critical stages. These are beyond just hearings. We don't need transcripts for it. You can see the transcripts we have wherein the state talks about, I've been having plea negotiations with Mr. Allen. Mr. Allen and I have talked about stipulating the video. Your Honor, he's going to stipulate to all our video coming in without us having custodians. That infected trial. He wandered around in the dark for 14 months without his eyes opened, as this court has said, from Buckwall to Burton to Jones to today, hopefully, that their eyes have to be open to make that decision. And we cannot retroactively go back and determine that over that 14-month period, the lack of attorney guidance didn't infect his trial outcome. It's not outcome based on his part. It's structural error. It shouldn't be subject to harmlessness. But even if this court finds that it should, they could never meet their burden and prove it harmless. And in fact, the record shows a number of areas where we should presume harm.
Thank you, Mr. Sokoloff. John Teske, you reserve 3 minutes.
Thank you, Justice. I'll attempt to not take the 3 since I know I've gone far over. The United States Supreme Court has held that the denial of counsel in certain critical stages is not necessarily structural, and this court should follow suit because there are cases, and this is one of them, in which the record can be utilized to conduct the harmless error analysis. It's not a free-for-all. It's not a get-out-of-jail-free card for the state to deny defendants counsel. It's simply giving the state an opportunity to argue harmlessness. That's what I'm seeking here. My brief sets forth why it was harmless here. But this court, before it gets to that, should find this error is not de facto structural. The 10th Circuit found as much when it examined the denial of counsel at 2 pretrial critical stage hearings. The case citations are in my brief. The First Circuit found the same thing in 2002 when it held that a short-term localized denial of counsel can be examined for harmlessness rather than be deemed structural. The Fourth Circuit found the same in 1997 when it said it will only be put under the structural error umbrella if the denial of counsel was total and contaminated the trial. That did not occur here. The Ninth Circuit in 2002 said the denial of counsel at a sentencing only hearing does not infect the trial itself.
Well, even the
Another-
U.S. Supreme Court has said that in a case that when a defendant didn't have counsel at an arraignment, which is clearly a critical stage, it could be reviewed for harmlessness.
Right.
Even the U.S. Supreme Court said that, right? But the U.S. Supreme Court has never said that lack of counsel at a competency hearing where the defendant thereafter represented himself is subject to a harmlessness analysis.
It has never said as much under those facts. You're correct. It has never deemed those to be structural, but it has never deemed that fact pattern can lend itself to harmless error analysis. To the question about whether or not how this case differs from a case in which the competency hearing just didn't happen, to Justice Steagall's question. This court has said that retroactive competency evaluations can be done and that cases can be remanded for as much. Harold Glenn Ford is the example from Johnson County. The case was remanded for the district court to consider whether or not a retroactive competency evaluation could be done, and if so, conduct one. The case was remanded. That case was much older than this one at the time, and it was delving back 20 or 25 years, I believe. And the court in that case found it could not conduct the retroactive competency evaluation. In that case, there was a transcript lacking of the competency hearing. So we just didn't have a record of what happened in the original competency hearing. So this court has acknowledged that those retroactive competency evaluations can be done. And I believe this case lends itself to as much, given that we have copies of all of the evaluations that were done by the doctors. Another one could be done. But whether an error occurred in that hearing, that competency hearing, should be examined for harmlessness rather than unwinding the entirety of this trial. Finality means something, and we should still recognize the burden this trial placed on this particular victim when one looks through the facts of this case and what this case meant to that victim. That should be part of the calculus as to whether or not we're going to deem a very localized pre-trial rights deprivation as structural or not, especially when the record lends itself to examination later as to whether or not that hearing prejudiced the defendant. So to the extent this court is open to as much, I would welcome the case being remanded for a retroactive competency evaluation if that would allow this court to acknowledge no prejudice befell the defendant at that hearing, and thus nothing infected the trial thereafter. Thank you.
Thank you, Mr. Gonteski and Mr. Sokoloff, for your arguments this morning. That concludes the March docket of 2024, and court is adjourned.